Thank you for joining the Business Operations Educational Conference as part of the 2021 Virtual Southeast Regional Fruit and Vegetable Conference. I'm Beth Olson. I'm the Director of Education for the Georgia Fruit and Vegetable Growers Association, and I'm going to be the moderator for this presentation today. This presentation is being done live, and we will continue to take questions as we have throughout the rest of the conference by submitting questions at any point in time in the questions box. So again, if you have questions, type those in the questions box and press send. Don't forget to thank our 2021 conference sponsors and exhibitors by visiting the virtual trade show and featured products pavilion. And before we get started, don't forget to join us each morning for coffee chats and each evening for networking. Check out our conference agenda for details. So now I would like to introduce our two speakers. We have wage and hour attorney Marty Heller and OSHA attorney Travis Vance, both of Fisher Phillips. They're going to be doing the presentation entitled, What You Need to Know About DOL's New Rules and Response to COVID. I'm excited about this presentation because it's taking two different aspects and applying it really to one governmental approach to agricultural organizations. So preparing for all the different angles that the Department of Labor might be able to bring and or OSHA may be able to bring. Today, they're really going to focus on what you need to know about the U.S. Department of Labor and OSHA's new rules, how they impact your agricultural organization, the agricultural community, and our H-2A employers, and what to do when the DOL arrives at your workplace, asking questions about your safety and your pay practice. So, who are these guys, you ask? Great questions. I'd like to introduce first Marty Heller. Marty is a member of the Fisher Phillips COVID-19 Task Force, a cross-disciplinary team of attorneys dedicated to advising employers on the many workplace law aspects of the global coronavirus pandemic. Marty is an experienced litigator and wage and hour guru. Marty is a partner in the firm's Atlanta office and a core member of the firm's wage and hour practice group. A significant portion of Marty's practice focuses on wage and hour law, including minimum wage, overtime, timekeeping, and exemptions under the federal law. Marty advises clients nationwide on preventive issues, representing employers in governmental investigations, and conducting compliance audits with respect to wage practices. Marty also devotes much of his practice to providing effective and efficient general counsel to his and the client's firm, with a focus on resolving difficult issues to avoid litigation. However, when litigation cannot be avoided, Marty defends his clients in criminal and harassment claims as well. Marty has been listed in Georgia Super Lawyers and Rising Stars since 2015 and is a resident of Cobb County, where he resides with his wife, 2 children, and 3 dogs. And if we're lucky, I bet we get to see one of those 2 children or 3 dogs today. I know with working from home here lately, my 2 kids often run in on our webinars. Following him is Travis Vance. He is also a member of the COVID-19 Task Force for Fisher Phillips. He's assisted over 500 companies during the COVID-19 pandemic and remains committed to serving companies to protect the safety and health of their employees. Travis has received over 40 requests to speak on topics concerning the pandemic. I'll stop here and say that both Marty and Travis were a part of our Georgia Agricultural Labor Relations Forum later in 2020 and did a great job. Travis is dedicated to responsive client service and forming partnerships with community or with companies to help tackle their most difficult and high-profile issues. Having gained a reputation as a professional and aggressive advocate for his clients, Travis has emerged as a thought leader in the field of workplace safety. Travis is also a partner in the Charlotte office and a co-chair of the firm's Workplace Safety and Catastrophe Management Practice Group. He's tried matters across several industries and various subject matters, including employment litigation, business disputes, and matters prosecuted by the Mine Safety and Health Administration and the OSHA, and what we know as OSHA, the Occupational Safety and Health Administration. He uses unique or outside-the-box approaches to counsel employers and owners of all aspects of employment law and development of preventive policies and procedures to avoid employment and workplace safety-related claims. Travis handles litigation in both the federal and state courts, as well as claims pending with state and federal agencies. He's a member of the Rotary Club in Charlotte and speaks frequently there. He also serves on the board of directors for the Blue Ridge Safety Association, a trade group for safety professionals. So now that you know our speakers and a little bit about where we're going, Marty, I'm going to pass it off to you.
Thanks so much, and welcome everybody to our webinar today. Appreciate the introduction, Beth. So as Beth mentioned, we are going to do a DOL update, and I will say, talk about a timely one for sure, as you know, when we start talking about what's going to happen with the Department of Labor, you know, starting in 20 or so days, you know, we're talking about a transition in the who's going to lead the wage and hour division, who's going to lead the Department of Labor. And so Travis and I will do our best today to both chat about what the content of our slides are, covering obviously, you know, the critical issues affecting employers from the wage and hour side, from my perspective, and from the OSHA side, from Travis's perspective, but I'll also try to give you some insight on what I expect to see coming. Because as inevitably happens with change every 4 to 8 years, sometimes more or less, we often see dramatic changes in the way that we expect the Department of Labor to handle some of their interactions with you. So without further ado, I'm going to go ahead and get going, try to keep us on time today. One question I get quite frequently, and especially from the ag industry, is, look, we're covered by H2A, we pay AEWR, which hopefully we all know AEWR is a little bit up in the air right now. But we pay AEWR, we're subject to MISPA, we're not really too concerned about the FLSA. What's the big deal about the Fair Labor Standards Act? And I will say this is one of those areas where if you haven't been sued for an FLSA claim before, or if you haven't been subjected to a Department of Labor wage and hour audit under the Fair Labor Standards Act before, consider yourself lucky. This is an exponentially increasing claim. You know, I started practicing law in 2008. And when I started practicing law, I remember sitting down with the managing partner of my law firm at the time and saying, well, I really want to focus on Fair Labor Standards Act claims. I think that's what I'd like to do. And he laughed a little bit at me and said, you know, there's not enough of that work to focus on that kind of work. You know, that could be you know, one type of claim that you handle, but that's on the side. You need to really focus on something that has enough work, that people see enough to be your area you focus on. And, you know, he may have been right in the 2007, 2008 timeframe, but in 2021, I can tell you it is its own practice area. This has grown so exponentially that between 2000 and 2017, when we saw what I'll call an artificial plateau, we saw an increase of almost tenfold in the national filings. And when I say it's an artificial plateau in 2017, we've seen a consistent number of federal filings since then. We haven't seen a dramatic increase, but it's a complete false narrative to think that they are not increasing, because the reality is, since 2017, most of the West Coast states, several East Coast states have enacted their own state law versions of the Fair Labor Standards Act. So what we've seen is not an increase in federal filings at the same exponential level we saw before, because in California, you would never file an FLSA claim. You would file a state law claim under their wage orders or under what they call the Private Attorney General Act, a PAGA claim. Just like in New York, you wouldn't see very many FLSA claims because of the protections that are provided by state law. So the fact that we didn't see a decrease in the number of federal filings under the FLSA from 2017 to the present is concerning. It shows you how many filings there still are out there. So the plateau actually means continuing the increase. So what has caused this increase? And I get this question a lot, and I wish there was a great answer for you. And there's not one terrific answer. I think it's a significant number of different things interacting, cumulatively causing this increase. Start with the basic assumption that, and this is true for Travis and OSHA claims as well, but start with the basic assumption that for 15 to 20 years ago, if you wanted to find out whether you were properly classified as an employee exempt from overtime, you're going to have to find the closest law library. You're going to have to set up an appointment with the law librarian to figure out where the books and treatises are on the FLSA. And then you're going to have to sit down and spend hours. And now, the Google culture allows you to simply type in, H2A agricultural exemption outside produce. And immediately, and you can throw in Georgia into that, and immediately you're going to see, boom, all these lawsuits that have been filed, a bunch of articles that people have written, all telling you about their opinion on whether a particular type of position might be exempt. So the Google culture has dramatically changed the availability of this information. Take with that the aggressive marketing that we're seeing. So for those of you that work from home any amount during this pandemic, you probably see these daytime ads all the time for law firms. And of course, for the people, that's the Morgan & Morgan ad. And 15, 20 years ago, Morgan & Morgan was workers' comp and, car accident, personal injury cases. And now they have an incredibly active FLSA practice with good lawyers. And so it just shows you that these groups that used to focus almost entirely on personal injury are now advertising to get people to come in. Take those and add to it that the FLSA doesn't care what you intended to do. Your intent is irrelevant. All that matters is whether someone was paid correctly or not. And a successful plaintiff, if this is a lawsuit and not the DOL, recovers their attorney's fees. So you combine all those things together, along with how complex it can be to comply with the FLSA. And when I do these presentations in person, I'll often show you a copy of my regulations, even just the white collar regs to the Fair Labor Standards Act, and show you how thick they are, because compliance is difficult for attorneys, let alone for someone who wears 3 to 4 to 5 hats for their employer, and none of which is in-house counsel. You're serving as HR, you're serving as director of operations, you're serving as payroll, and you're also trying to figure out the FLSA, which can be quite difficult. The cause of the increase is one significant issue that we have to consider. The second thing that I think is really important is understanding when these lawsuits come, the significance of them. And what I mean by that is, I have a slide, it's not in our slides today, but I have a slide that shows the average FLSA settlement and the value based on the percentage of cases that are filed. And more than half of FLSA cases settle for $100,000 or more. And if you consider that the vast majority, 9 out of 10 class action employment cases that are filed in this country are filed as FLSA cases, that can, at least for now, I say for now because the unique geographical scope of including the whole country is being considered by a lot of district courts. So we might see a Supreme Court weigh in on that in a few years. But it can be national. So if you have operations in multiple states, you could be facing one lawsuit in one state that encompasses all of your employees. And you realize that the $100,000 case in the 50% likelihood is actually low, because when you get up to the 2, 3, 4% of these lawsuits settle for over $1 million, that's not that small of a number for the number of these lawsuits that settle in that figure. That's actually a pretty significant percentage settle in that million plus range. And so you start to realize that a lot of these, especially for those of y'all with smaller farming operations, are bet the company. They're bet the entity lawsuits. So you got to try to make sure you're getting it right on the front end. So I'm going to spend the rest of my time talking about how to survive a DOL audit. And this is where I'm going to really focus on what I think we're going to see coming, because a lot of this is going to be focused on best practices to ensure that you get your attorney involved as quickly as possible. You avoid the potential for liquidated damages. You avoid the potential for what they call CMPs, which are civil money penalties. And you avoid the potential for the case getting publicized and turned into a class action when the plaintiff is pulled. So let's start with the basics. The DOL is on your doorstep. It's 7:30 a.m. There's 5 or 6 people in the office, and somebody is out in the parking lot asking to speak to whoever is in charge of operations, and they showed you a badge. They often will show the badge and act as if they're there for law enforcement purposes when they're not. So what caused that? Well, there's a lot of different things that cause it. One is employee complaints, and this happens very frequently. An employee who you either fired or who you've disciplined calls and says, hey, I think they're paying me wrong. Hey, something here is going incorrectly with pay. I think you should examine it closer. Very frequent. There are other pre-programmed, if you will, specific industry programs that are intended to focus on different industries that they consider high risk. So over the last 4 years, we've seen a whole lot less of this. This was very, very popular during the last 2 or 3 years of the Obama presidency. And I would say this is one area I expect to see a return on. I'm hopeful that the focus won't be as much on agricultural employers, but I will say a lot of that depends on what happens with these AEWR regs that are currently enjoined, and how are they going to be impacting individuals moving forward. And if they decide to move forward on a mass scale basis with some of what we've been concerned about, and we're not going to cover the AEWR regs today. That's a whole different presentation. But if some of the concerns on fruition, I can tell you that I can see that being a very focused area from the DOL. Media reports and private litigation also often drive the DOL's selection of who to audit. I will say, and Travis will probably talk about this a little bit, but COVID cases, reporting COVID cases, complaints of COVID cases. The Wage and Hour Group is now showing up with OSHA to do DOL investigations together, which is interesting and sometimes leads to some problematic results for employers. So something to keep in mind, this idea that other agencies or complaints made to other parts of the DOL can lead to multiple investigators arriving on the same day. And then, random audits still happen. I will say random audits are just incredibly infrequent these days. So you want to go ahead and plan in advance for these types of things. I like for my clients to know who do they need to call within 15 minutes of finding out that the DOL is on site. Call me, have a backup for me, call whoever is going to be the liaison for the Department of Labor during the day. Keep in mind, you can tell the DOL just right outside of your car, we'll be out there in a minute, and we'll send somebody out to meet with you. For a lot of my clients who aren't within driving distance or aren't close enough to me, I can't be there on site to help. But I can be on the phone, and I can direct someone ahead of time on how to prepare for it. And so that's where you want to make sure you have that liaison prepared. Someone who is your director of operations, someone who's your CFO, who's the point of contact, who will direct the Department of Labor where they can and cannot go during the day, and will be the one responsible for talking to them because you don't want them just wandering around, poking their head places it doesn't belong. And I know Travis would tell you, limit the scope for the OSHA investigations.
Absolutely.
And for the wage and hour investigations, limiting who they talk to, continuing to reiterate to them that the investigation and speaking with employees is interrupting operations. Put them in a conference room and bring people to them instead of having them walking around. These kinds of things, planning ahead for, mean that you don't end up calling someone 2 hours into an investigation. And when, let's say they call me, and my first question, okay, who's talked to them so far? What have they seen? What documents have they looked at? Who have they interviewed? And if the answer is, I have no idea, we're in a much tougher position to respond than if we'd planned ahead of time. I would say making sure, and this is really important, that you either don't give the DOL any documents when they're out there, and Travis will say something different about OSHA logs, but on the wage and hour side, not giving them anything when they're out there, but agreeing to provide it for 48 hours is very effective, so that you can have copies of everything they've asked for, and make sure if they do take anything or if something is provided to them, get copies, date it, take detailed notes of who met with them and what they were provided. Some of this will be a little bit repetitive, but just keeping in mind that we want to make sure that the process from the second they arrive on the front doorstep to the second they are escorted out of the place of business, off of the farm, out of your office, whatever it may be, that someone is always with them, that they are not being allowed to simply roam around. That's where you get yourself into quite a bit of trouble. I do have a lot of clients that say, well, I want to sit in on every single interview. I do have to remind them, you can sit in on the interview of anyone who's considered management. Anyone that would bind the company from a wage and hour perspective. However, you are not allowed to sit in on the non-exempt employee interviews. So it's a good idea to have in your mind, if they ask for, hey, I'd like to speak with 5 or 6 or 7 non-exempt employees, have in mind who you think that should be, so that you can say, okay, well, I'll bring you 3 workers from the packing shed and 3 workers from the field, and you already have a good idea of who you want to bring to them. It's a good idea, since you're not going to be able to sit in on the interview for those hourly employees. So one of the other questions I get quite a bit from my clients is, well, what authority do they have to be out here? How can I say that you don't have a right to look at my payroll or talk to people? And there's a lot of different authority for the DOL to be out there, and it really depends on what their authority is. When we're talking about wage and hours authority under the FLSA and under MISPA, specific to H-2A, their authority is fairly broad. They have the right to request anything that you would have to submit pursuant to your certification for H-2A. So they can inspect housing, they can inspect vehicles, they can look for records related to that, they can ask for payroll records, they can ask for time records. And one of the things I like to say from the wage and hour perspective is, be firm but be reasonable. And if you take the firm but reasonable approach, I think you'll find quite frequently that the Department of Labor is willing to say, okay, I'm not going to make you provide 2 years worth of pay and time records. I understand that's a giant pain and a ton of documents. How about instead you give me the last 2 payroll runs with the time and pay records that go with them? And I'll start from there. And if we see anything, we can discuss it further. And if you start with an approach like that, I think you'll often find that the desire from the DOL isn't to immediately be difficult, as long as you take a reasonable approach and response. But you do have to be firm and can't, if you say you can have whatever you want, DOL is going to take everything that they are permitted to get. And, obviously the more documents you give, the more time they spend talking to people, the more likely you are to run into some type of issue.
And I'll just jump in real quick, Marty, because this is a question we get a lot. It's like, well, what if I hire a lawyer? They're going to be harder on me. I can tell you from the OSHA side, my experience in the last 6 months and the year is actually it's the reverse of what people think. So if you get a lawyer, they will be less likely to be hard on you. And what you see from a lot of these investigators is they kind of smell blood in the water. An employer without counsel, whether it's wage or hour or OSHA, and they'll just steamroll you, get all those documents, and they'll just line you up for heavy fines. Whereas if you have counsel that can help you push back professionally, it'll actually end up saving you a lot of money in the long run. And that's not a shameless plug for counsel. It's just reality right now. It's my what I've experienced.
Yeah, and to reiterate that, I think it's a really good point, Travis. And to reiterate that, I think on the wage and hour side, I think especially with larger H-2A employers, I actually think they're surprised when you don't have counsel there and think they can take advantage of you. They expect to see either counsel in person or on the phone, or at least to hear that you're represented. That's what they're used to. And as long as your counsel establishes that reasonable but firm approach with you, I think it can be an incredibly important part of surviving and not getting taken advantage of. So just to finish up on my slides, and then I will hand it over to Travis. So one thing to think about ahead of time, and I mentioned conference rooms for interviews, but quite frequently you're going to have a DOL investigator who wants to interview H-2A workers who might be in the field, for example. And so having some sort of plan ahead of time of where you might be able to interrupt operations the least. Can you have interviews take place in a centralized area that's very close walking distance from the fields? Are there meal breaks that you could stagger that might allow you to have interviews take place? Or could you do breaks for the employees, of course, paying them while they're speaking with the investigators? Please don't have them clock out or we'll have a separate wage and hour issue. But, having that set ahead of time and making sure that your employer representative, your liaison, is aware of what management interviews are acceptable. If there are some you're not sure about, to tell the DOL, look, they're not available today, but I'd be happy to make them available at a later date. Let us know your schedule. Again, it's that idea of being firm, but also being reasonable. Just a few more slides on the wage and hour side, but documents the DOL may want that you may not have to provide. But let's start with the one they always ask for. We want to see all your revenue. We want to see exactly how much money you've made over the last 2 or 3 years. Well, they're asking for that to establish coverage under the Fair Labor Standards Act. And pretty much every jurisdiction, there's still 1 or 2 states that have their own kind of quirky rules, but pretty much every jurisdiction will allow you to concede jurisdiction coverage under the FLSA. So if you're uncomfortable or you don't want to provide all these revenue documents, one of the easiest ways to avoid having to do that is to say, look, we're not objecting. We know we're covered under the FLSA. We know we're covered under MISPA. Let's move past that and start talking about the actual requirements of these laws. And then talking about trends real quick, and I hit on some of this earlier, but I've had this happen, I think, 3 times now in the last year, where a client has called and said, wage and hour is here. And I've said, oh, okay, who is it? What's the investigation based on? What have they told you? And they've said, oh, it's something about COVID and OSHA's here too. So I know Travis is going to talk a good bit about the COVID and OSHA, so that's transition to Travis. But I will just say, be very cognizant of the fact that as COVID cases get reported, and there's different requirements for whether you have to report or not, but as COVID cases get reported, and more importantly, as the DOL finds out about COVID cases, often through the media or through an employee complaint, they're showing up, and they're showing up with OSHA and wage and hour together to do a joint investigation. Travis, I'll hand it over to you.
All right. Thank you, Marty. Appreciate it. And thanks for the introduction earlier there, Beth. I'm going to just toss it over to OSHA and investigations and what we're going to expect probably in the next couple of years or so with the new administration coming in. I'm going to hit on a few things with respect to highlights with respect to COVID issues, and then also talk about what can we expect from OSHA in the next 2 years or so. So what has been going on under the Trump administration with respect to COVID-19? They have not issued a COVID-19 standard under federal OSHA. If you're in certain states like Virginia, Michigan, Oregon, and California, they do have COVID-19 standards in those states, but there is no federal OSHA standard. So with respect to enforcement, the federal OSHA has been having to rely on what they call the general duty clause. That's the OSHA's generic requirement that you have a safe workplace. So OSHA has said that if you do not comply with the CDC's guidance with respect to COVID-19, they could issue a citation under the general duty clause. Haven't seen a lot of that. We'll talk about the ones we have seen. But the Trump administration has not been that aggressive with respect to COVID-19 issues and has certainly not been aggressive enforcing the general duty clause. Now, what we will see probably January the 21st or so is a different approach with respect to COVID-19, and we'll talk more about that. So what's OSHA doing right now with respect to COVID-19? They are looking at personal protective equipment, especially respirators. So the N95, the dust mask that you can buy at your hardware store, you may not realize that that's a respirator, but it actually is. OSHA considers dust masks, N95s, to be respirators. And if you're requiring your employees to wear N95s or even on a voluntary basis during the pandemic, then you're required to have a respiratory protection program or at least part of it. We see a lot of OSHA inspections where employers are requiring N95s and they're not fit testing the employees, not giving them a medical evaluation. That's probably the number one type of issue that we're seeing right now. But again, N95s, dust masks that you could buy at the hardware store are in fact, those are in fact respirators under OSHA standards. Another issue that we're seeing with respect to COVID-19 and OSHA inspections is they're looking to see if you're recording COVID-19 cases that are work-related on your 300 log, which most employers that have more than 10 employees are required to keep. If you've never heard of an OSHA log, you can ignore OSHA 300 log. You can ignore this part of the presentation. But if you keep 300 logs, you have to note on the 300 all COVID-19 cases that are work-related. And we'll talk more about that. We see a lot of employers that are not doing that. We also see that a lot of employers are not reporting certain COVID-19 cases that result in fatalities and hospitalizations to OSHA, and that could result in citations as well. So with respect to recording COVID cases on your OSHA 300 log, back in April, OSHA said, we're really only going to make 3 industries do that unless it's absolutely obvious. And those 3 industries were healthcare, emergency response organizations, and correctional institutions. OSHA got a lot of pushback on that. So in May, they came back and said, just kidding, it actually applies to all industries. All industries that have to keep 300 logs have to figure out where Johnny from maintenance got COVID-19. So it's really a 3-step process. It's really ask Johnny. I always pick on Johnny as the employee who had COVID-19. You ask Johnny where do you think he got COVID-19? Then you ask Johnny about anything outside of work, his cousin Bubba's barbecue, or is there anything in work, like a customer or a member of the public he dealt with respect to where he may have gotten COVID-19. And then you have to take a look at Johnny's workplace and say, was Johnny around a coworker, or was he around somebody that led to him contracting COVID-19? Once you've done that 3-step process there on the screen, you're in a position to either record Johnny's case as work-related or not put it on there, but at least you have a memo and an investigation in the file in case OSHA shows up. If you need and at the end of this, I'll go back and hit this, but we've got a decision tree that we have for work-relatedness in COVID cases. Be glad to email that to you in case you need that. Now with reporting, I mentioned that really only 2 types of cases that have to be reported to OSHA. That's where you pick up the phone, not just record on your 300 log. And keep in mind that reporting OSHA cases, hospitalizations, fatalities, that applies to all employers, even if you don't have to keep a 300 log. So the only 2 times you pick up the phone and call OSHA is when Johnny dies within 30 days of an exposure at work, a work-related COVID-19 case. So if he goes home on January the 1st because he's sick and then he dies on January the 17th, and you need to pick up the phone and call OSHA. Keep in mind, California does not have that 30-day window limitation. So if it was 60 days in California, you would still call. Also, if Johnny goes immediately to the hospital within 24 hours of leaving work, you would need to call OSHA. If he goes 48 hours later or 2 weeks later to the hospital, you do not have to call OSHA. It has to occur within 24 hours of him being at work. So if he's hospitalized 2 weeks later, you only record that on your 300 log, but you do not have to call OSHA. That's a very important wrinkle that a lot of people miss. With respect to being prepared for an OSHA inspection, if they show up, as Marty said, you're going to limit what you're going to give them. One of the things that you're going to give them within 4 hours is your OSHA 300 logs. That's really the only thing you have to give them in a certain amount of time. But if it's COVID related, they're going to ask for your COVID action plan, response plan, prepared plan, whatever you may call it. It's not required by federal OSHA, but Virginia requires it. California requires it. And even if you're in a different state like Georgia, you should have a written COVID-19 response plan. And the reason for that is if OSHA shows up or they send you a complaint and you need to respond to it, it's hard to articulate what your COVID-19 action plan is if it's not in writing. So it's a very good time to go ahead and get that in place if you haven't done it. Make sure you have the right PPE. Make sure you've trained your managers and supervisors. What are your cleaning and disinfecting protocols? How are you keeping the workplace safe and clean? Make sure you have that in place. Make sure you go ahead and train your employees and also train your managers. One thing we've learned during the pandemic is that managers and supervisors need to have a good bedside manner when it comes to COVID-19, because if an employee goes to a manager and says, hey, what are we doing to keep the place clean? And the manager kind of hems and haws and doesn't really know, it doesn't send a good message to the employee. It's kind of like a doctor or a lawyer with a bad bedside manner. If the lawyer or the doctor is freaking out, it's going to make the client or the patient freak out. So same thing happens with respect to managers and supervisors. So what's going to happen under the Biden administration? Just a couple of weeks away, as Marty noted, we're going to have a head of OSHA under Biden. We're actually going to have an assistant secretary of labor who is going to be charged with leading OSHA. We never had one in Trump. Under Trump, the Trump administration, Scott Mugno from FedEx was nominated, but ultimately withdrew his name from consideration in 2019. Biden, I've seen about 3 different names tossed around for the job. A couple of them are very, very labor friendly, would be very, very hard on employers and very aggressive with respect to enforcement. And the third one is from California, where, of course, they have a lot more enforcement, a lot more regulations. So whoever it ultimately ends up being is going to be very employee friendly. You're probably going to see more consultation. You're going to see more working with employers to keep them safe on the consultation side, but very aggressive with enforcement and also with adopting new rules and then pulling some old rules out of the closet, so to speak, and start enforcing them again. And we'll talk more about that. One of the other things OSHA will do is they'll start actually having committees. They have some advisory committees on maritime, general industry, construction. Those will be filled and will meet with OSHA and voice industry concerns. That had not been the case under the last 4 years. So if you have a trade group or some sort of group that would like to participate in those, it's a good opportunity to get your voice heard with respect to federal workplace safety enforcement. Now, I mentioned in Virginia and California and Michigan and Oregon, they have temporary standards for COVID-19. If you're in one of those states, you need to take steps immediately to comply with them. Trump administration has never attempted to do that at the federal level. But I think you could see that on day one. I've heard folks say that this would be in place by the end of January, an emergency temporary standard for federal OSHA. And if it's anything like Virginia or California, I think it'll end up being more like Virginia. then you can expect for it to require at least a couple things. One, for you to have a written COVID-19 response plan in place almost immediately. So be ready for that. And also there will be a requirement that you make notifications to the health department and or more notifications to OSHA immediately too. So to get ready for that, we anticipate that will be coming at the end of this month. Other things that we think that the Biden administration would want to do, they're going to work with unions to enforce OSHA standards to make sure that first responders and essential workers are kept safe. They're also going to use the general duty clause to enforce the CDC guidance to the extent that they're not enforcing the emergency temporary standard. So federal OSHA is going to be very aggressive, whether it's this emergency temporary standard or with respect to the general duty clause. Now, what are a few things that we have seen during this pandemic that have really been missed by employers? These are the top 4 things that I've seen, having worked with numerous employers at this point. But bringing employees back too early after they have a negative COVID test. So whether that's 14 days or 10 days or whatever the quarantine period might be in your locality, they don't need to be coming back before that time period if they get a negative test because they haven't gone through the incubation period of the virus. So if someone's exposed to Johnny, they need to be out for the 10 or 14 days, whatever the quarantine period is for your state. And if they get a negative test on day 3, that doesn't mean they can come back. Same thing with respect to household members. So if Johnny's wife is sick, he needs to be out from 10 or 14 days from the time he was last exposed. So that's his wife is going to be sick for 10 days at least under the CDC guidance. So Johnny's actually going to be out for 20 or 24 days. It's not overlapping periods of time. So just keep that in mind. Not notifying employees of confirmed cases. Our law firm's keeping track of all the lawsuits with respect to COVID-19. The number one type of lawsuit we see is a failure to notify employees of a confirmed case. And under the Biden administration, they're going to start citing employers who don't do that under the general duty clause. And it's actually in the CDC guidance as well that you should be notifying employees of confirmed cases. And then finally, when you're doing the 6-15-48 analysis, which is what we quipped at Fisher Phillips, it's those folks who are within 6 feet of Johnny for 15 minutes or more during the time period of 48 hours before he had symptoms or later. Those folks are the ones that had direct exposure to Johnny and need to be quarantined. And it doesn't matter if those folks had mask on or not, or Johnny had a mask on or not. A lot of employers have not been counting those folks who had mask on, but it actually doesn't matter under the CDC guidance. So just keep in mind those types of things with the Biden administration enforcing the CDC guidance under the general duty clause. Those are the types of things that could end up leading to OSHA citations. And another reason why they will is because Biden has promised to build up the number of OSHA inspectors. In fact, he says that they should be doubled. Right now, they're at the lowest point in OSHA's history. He wants to double them. Now, that won't happen on January 21st, but it'll take about 18 months for them to be hired and to be trained at the Officer Training Institute up in Chicago that OSHA uses. So in about 18 months to 2 years from now, you can expect a lot more OSHA inspectors out in the field. Marty gave you a lot of pointers. Anything that you say, especially a manager or supervisor, is going to be used against you. So the key is no manager interviews. Take a list of the documents other than the 300 logs. We'll get back to them later. And the reason for that is because if you start handing things over, you'll lose track of it. As Marty said, you'll give them things outside the scope of the inspection. You'll give them things that are protected or privileged. And I tried a case for 7 days in Texas one time because OSHA just was unable to piece together the documents our client gave them. And because the client started giving to them in a piecemeal at the beginning of the inspection, OSHA wasn't able to go back and piece them together. And OSHA essentially cited the client for not having documents that they had actually provided to OSHA. And we litigated that for 7 days before OSHA finally realized it. So very important, take a list, figure out what you need to give OSHA, make sure it's complete, make sure it's not privileged, make sure it's not outside the scope, and then you can provide it. You don't have to hand everything over to them at the time of the first day of the inspection. So just a few other things to keep in mind is that there's a few things that the Obama administration adopted that's kind of been forgotten, but still out there. And we think Biden will revive those. The first one is that for most employers that have 250 or more employees at a single location, or for some employers that have 20 to 249 in certain industries, you'll have to report the information on your 300A summary to OSHA with its through its electronic portal. Trump administration knocked back the requirement to put the information on the 300 logs, but you still have to do the 300A even today. What we think under the Biden administration is that they will go back to the 300 logs as well, and that will be essentially public shaming companies that have high injury and illness rates. So something to look for, probably starting in 2022. We talked about general duty clause citations. We think OSHA will use the general duty clause to cite you for failure to follow a CDC guidance. Basically, under the CDC guidance, that is a recognized hazard if it's been published out there. OSHA says that you should have known about that hazard that was recognized. If it could cause a serious harm or death, then OSHA can use the general duty clause to cite you. So you may not be too concerned about following the CDC guidance now, but under the Biden administration, which will be much more aggressive doing this, just be prepared for that to take place. And then there may be an infectious disease standard adopted. What that is, it covers infectious disease not just for COVID-19, just like COVID-19 or just COVID-19, but also all other infectious diseases. And largely, this is going to relate to high-risk exposure workplaces and healthcare facilities. But look for the Biden administration to actually revive this proposed infectious disease standard. There was one proposed under the Obama administration, and Biden will likely adopt that, and it will apply to not just COVID-19, but also any future pandemics and other infectious disease, and largely, as I noted, apply only to high-risk workplaces like nursing homes and other medical facilities, but just something to keep an eye on as well. And as you likely know, about half of the OSHA states are OSHA's enforced by federal OSHA in that state, and then the other half is what they call state plan states. The state plans have really just done whatever they wanted to under the Trump administration. Hasn't been a whole lot of oversight, but look under the Biden administration to be much more aggressive with respect to those state plans, because states like North Carolina and South Carolina have not even increased their penalties like the feds did back in 2015-16. And look for the Biden administration to be much more aggressive about pushing them towards enforcement. So that's probably going to occur as well. So just in closing, before we get over to questions, with respect to one of the other Obama rules that's out there but not being enforced, this is probably the most important one and the one that most people have forgotten about. And that's the 2006 anti-retaliation rule that had 3 parts to it. The first is that you can't retaliate against employees who report an injury by making them have a drug test just because they reported the injury or accident. You also can't have discipline employees who fail to report an accident or injury immediately. And you also can't have a safety incentive program that discourages employees from reporting accidents. So with respect to drug testing, you can still drug test after an accident if state law allows or another statute like the DOT allows you to do that. And you can also post-accident drug test if you have a reasonable basis to believe that drug or alcohol impairment led to the accident. So we're not going to drug test Johnny because he reported an accident. We're going to drug test Johnny because he drove the forklift off the dock bay, and such action would be inconsistent with sobriety. So I'm sure everybody on here has a reasonable suspicion drug testing. And just hypothetically speaking, obviously, if Marty shows up walking across the parking lot, slurring his speech, smells like marijuana, you're probably going to drug test him. Same thing applies post-accident under this rule. You're going to drug test Marty, again, not because he reported an accident, but because his behavior or you have some other evidence that he was impaired by drug and alcohol. Again, we've got the language you can plug right into your policy. Be glad to email that to you if you want to email us at the end of the presentation. So this is what we think Biden's going to do. They're going to start enforcing that drug testing policy. And here's what's going to happen. OSHA shows up. They're going to ask for the 300 logs. They're going to ask for a bunch of documents. And it's going to be easy for them to say, let me see your drug testing policy. Could be outside the scope in some situations, but drug testing usually applies after an accident. And OSHA is usually there after an accident. So be prepared for them asking for that. And if it says on there, we drug test everybody because there was an accident or you reported an accident, you may get cited for that. OSHA can actually cite you for having an improper drug testing policy. So just be prepared for that. We are ready to assist you with that as we turn the page here with OSHA enforcement. Before we get over to some questions, a couple things. If you want to email me or Marty, I'll be glad to send over that reasonable suspicion language for drug testing policies that I mentioned, and also that decision tree for determining whether or not a COVID case was work-related, which is now required by OSHA as well. And with that, I will send it over to Beth, and we'll take some questions to the extent we have any. Thank you very much.
Thank you, Travis, and thank you, Marty. Never fail to impress. So thank you. This is great information. Now, Marty, I can't make comments about you and what your environment is, but Travis is a true OSHA guy. We've got an orange vest in the background. You've got a multitude of 3 to 4 inch binders there on the side.
Right. I've got a gas mask up here. Having an expert witness actually give me a gas mask. It's pretty cool with a canister and everything.
Nice.
I love that stuff. I love that. I love taking the freebies. So
absolutely. So we are going to take some questions, and even though we're doing this live, it's still within this webinar platform, so we can't hear or see the audience. But if you do have questions, please make sure that you type those questions into the chat box, and we'll pass those on. So I do have one. Where can we find the employee thresholds per type of operation?
Sorry, what would repeat that again, Beth?
Yeah.
Where can we find the employee thresholds per type of operation?
Well, I'm not sure if they're talking about OSHA, but the threshold that I focused on today was if you have more than 10 employees, and that's company-wide, then you have to keep the 300 log. I don't know if that was another question, but that was the threshold I'd focused on. I don't know if Marty, if you had any other ones.
Well, and as a question we sometimes get, which is how many employees do we have to be covered by the FLSA? And the answer is technically 0. Now you wouldn't really have a violation with 0. All you have to do is be engaged in interstate operations, interstate commerce. And there's some really broad definitions for what is interstate commerce under the FLSA. So, if you're using phones and accepting credit cards as a payment or from vendors in any way, you're covered by the FLSA. Now, there is an income threshold, which is $500,000 in gross income each year, gross revenue. But if you fall below that, you could still be subject to individual coverage as well.
Excellent. Thank you. Any other questions from the audience? Again, feel free to type those into the questions box and press send. It's interesting that we've got the forecasting into the new administration that's going to come in, and how different it's going to be in some areas, and then some ways where there'll be some similarities. So it'll be interesting to see how your both of your jobs pick up.
I can assure you, I think both Travis and I will remain very busy in 2021.
Well, and after all of our interactions with the USDOL, it definitely seems that there's a microscope on the Southeast, and I think even during the 2020 pandemic with COVID-19, and we may not have seen them quite as active on farms. I do think that there has been a quiet gathering in the background. So I expect to see them.
I've had more farm cases this year than I ever have. In fact, we just got a new one in yesterday. So I've seen more farm activity from OSHA than I have probably in the last 4 or 5 years.
Yeah. Okay. Well, we are not getting any other questions. I think y'all have done a really great job of overviewing all of this. So thank you, Marty. Thank you so much, Travis. Everybody that was in attendance, I know took tons away. Y'all got their contact information. If you need anything else from them, don't hesitate to reach out to me, Beth Olson with the Georgia Fruit and Vegetable Growers Association. Very, very happy to send you that information as well. So thank you, attendees, for attending this presentation. Don't forget to sign out if you are interested in pesticide credits. And don't forget that this presentation, as well as all the other educational content and our virtual trade show, will be available to you through April the 30th, 2021. I believe we're going to make that available this Monday, the 11th. Come back if you missed a presentation or just want to rewatch one. This would be a good one to rewatch. And thank you again for your presentation or for your participation. This concludes this presentation.